My guest on today's podcast is EEOC Lead Outreach and Education Coordinator and Public Relations Manager, Nicole St.Germain. Welcome to the podcast. How are you, Nikki?
Hi, thank you so much for having me today. I am doing great. Thank you.
Oh, fantastic. I'm so grateful and so honored that you are here, Nikki. For those listening into the podcast today and previously, I go on and on and on about the EEOC. And so you are very well versed in it if you are an avid listener of the podcast. I just won't quit. And we actually were very, very fortunate. The EEOC provided by Nicole St.Germain did in listening session through the ACA. Those that listen in know that I am the co-chair of the advocacy committee for the American Circus Alliance. And we try to bring you as much as we possibly can in terms of outreach, in terms of work that we're doing with a lot of government agencies, work with your lawmakers, with your representatives, and work with Washington, D.C. This is work that's never been done before on behalf of the circus industry. But the most important thing is that the circus industry shows up for important things, important outreach that agencies like the EEOC is providing for us. And so the EEOC, we are fortunate, we hope that we will be able to have a future listening session. We also were very fortunate that the EEOC provided in an outreach liaison at the Viva Fest. So if you attended Viva Fest in Las Vegas this past year, and you went to the American Circus Alliance listening session, you were fortunate enough to listen to a coordinator that came out on behalf of the EEOC to speak to everyone that attended there and then stayed for a very long time and spoke to anyone that wanted to discuss employment issues and equity with them and to learn. So what we're doing here today is we are going to go through as much of what the EEOC is with Nicole St.Germain of the EEOC. We are so grateful for her time. Again, we're very grateful for the dedication of outreach for the circus industry, for the by the EEOC, and everyone out there. Please tune into this episode. Please share it. It will be on Circus Talk and it will be distributed through the ACA. However, we need you all to show up for these listening sessions that we do have. We know that they are unique to the industry. We know that there's a lot of unknowns. We're also thinking about maybe doing 2 listening sessions where we split it up between employees and employers. I do hear everyone screaming at me right now that everyone wears a lot of dual hats. So you might be an employee and an employer at the exact same time, but we understand the complexity of the industry, and the EEOC is going to do their best in learning how to facilitate as much outreach for us because we are unique, which I hear all of you saying as well. And I understand that there are a lot of sensitivities within the industry that sometimes keeps everyone from showing up. But as much as you show up for castings for a job, you need to show up for things like the EEOC, things like the Safe Sport initiatives, and other things that we're doing with Washington, D.C., and within advocacy that we are trying to do to change the narrative in and around the circus arts industry. Again, things that have not been done before. So that is my very long lead-in. Nikki is very patient with me. I let her know that I was going to speak to you all first and let you know what the important aspect is of what we are experiencing today with the EEOC and through Nikki. So to get into it, Nikki, thank you again for your patience. I wanted to ask for a short background of your role with the EEOC and how you came to work with the EEOC.
Thanks so much. And I'm glad you gave that background. That's fantastic. So I've been with the EEOC since 2009. I actually had no idea who the EEOC was. I had just recently moved to California, was looking for a new job somewhere. I'd previously been a probation parole officer for the Commonwealth of Virginia. I'd come with like a forensic psychology master's degree, and I was just trying to find my spot. And posting came for the EEOC for a federal investigator. I'm like, okay, I really like this. It was all about diversity, equity, inclusion, which has been such a strong point in my life to be fighting for the rights of others. And this position alone was an ASL bilingual position, which I have been ASL bilingual since I started when I was 8 years old learning the language. And it was just so important to me to be able to marry my background in criminal justice with my ASL bilingual background as well. So, lucky enough, I got into the federal government. For anybody out there who's trying to get in, we all know it's tough, but once you're in, it really is a great place to be. I spent 7 years as a federal investigator looking into EEO employment discrimination charges. I've worked obviously, I have a huge background in disability cases with a ASL bilingual language skill. And then I also did systemic investigations, which are large scale investigations into companies at a national level or different companies that have policies or practices that affect a whole group of people or a larger group. 7 years into my stint with EEOC, I took the position of outreach and education coordinator, which gives me the opportunity to take the message of these EEOC on the road. Like myself, not a lot of people know who we are. And so I get the opportunity to go out into the communities and talk to people and let them know what their rights are in the workplace, that they have a place that they can come to and turn when they are facing discrimination, harassment, retaliation in the workplace. I also educate employers. So that company side, that other hat that a lot of people in your industry wear, I do an education piece for employers on what are their obligations under the law? How can we make sure they don't come before us? And if they do come before us, because people are going to file, what we all know in business, people are going to file complaints against a company no matter what. How do you respond to it? What are the things that you need to put in place to make sure that you are following the law and you can show that you're doing that? And then also, I am the public relations manager, which means I do all the interaction with press, public relations, press conferences, and things like that for our district as well. So that's my very long bio. So sorry.
It's amazing and fantastic, and it's great so that everyone tuning in can understand who you are, how you came to it. And again, because the EEOC can be somewhat elusive for folks that are employed, I'm fortunate that I came to know the EEOC many years ago. I did want to throw in there before I ask you what is the EEOC and what does the EEOC do, is that there was a very, very popular case that happened with Cirque du Soleil several years ago. And it was one of the biggest judgments, I believe, by the EEOC, where this artist ended up getting a judgment of around $600,000. And they brought their claim. They were HIV active positive. They were hired by Cirque du Soleil. They were working for Cirque du Soleil. And then upon artists finding out that they were HIV positive, they ended up being dismissed from their contract and pretty much fired. There was a loophole in the contract that Cirque du Soleil had at that time that they said that they would not normally have. That was really one of the only reasons why this artist was able to bring about their claim and actually win it. That loophole has since been changed, which I always have found fascinating. We are hoping to have that victorious claimant through the EEOC, his name is Michael, participate in an upcoming listening session or on the podcast. He likes to stay underneath the radar. I have been speaking to him for quite some time, but he is a very behind the scenes influencer, I would say, of the EEOC, and he is very helpful behind the scenes for any artist or any person, actually, circus worker or anybody thinking about filing a claim. But I wanted to remind listeners that that is a very big case that happened, and that there are many other little cases that maybe weren't to that magnitude, but no less in importance. And so from there, Nikki, I would love to ask you, what is the EEOC? We hear those letters a lot. I oftentimes say those letters because sometimes when you say the full name of what the EEOC represents, people get even more confused. So they usually can pick up the EEOC a little bit better. And then what does the EEOC actually do?
Sure. Yeah, and you're right. I just jumped in. I was like, oh, EEOC. Didn't even think to spell it out. So the EEOC is the United States Equal Employment Opportunity Commission. So our agency was really born out of the civil rights movement. You know, we just celebrated the 60th anniversary of the March on Washington this past August, and we're coming up on the 60th anniversary of the Civil Rights Act. Within that act itself, the EEOC was created. It's embedded into that act. So our doors were opened a year after that was signed by President Lyndon Johnson. So we really were born out of that struggle. And it's really a victory that we came about. We have always been a small federal agency. We are independent of other federal agencies. So you're not going to find us under the Department of Justice or anything else, because not only are we tasked with investigating and enforcing federal discrimination laws on private employers, so that's like your Cirque du Soleil or your Walmart or your Lowe's, but we're also for public employers, so that's more of your state and local government, your school districts, your universities, but we're also tasked with making sure the federal government itself doesn't violate federal laws. So that's why we stand independently. Part of what we do is investigate and enforce federal law, right? So there are a number of laws that we enforce that protect individuals from discrimination, harassment, and retaliation in the workplace. We enforce the Equal Pay Act, Title VII of the Civil Rights Act, the Age Discrimination and Employment Act, the Pregnancy Discrimination Act, the Rehabilitation Act, the Americans with Disabilities Act as amended, the Genetic Information Non-Discrimination Act, and brand new, signed in December of 2022, the Pregnant Workers Fairness Act. So we enforce all of these laws, and what it ultimately means is that people who work in the workplace have the right to work free of discrimination because of their race, their color, their religion, their national origin or ethnicity, their sex, including sexual orientation, gender identity or gender expression. We look at pregnancy. You have the right to work without fear of losing your job or being discriminated against because of your pregnancy, because of your disability or perceived disability, because of your age if you're over 40, and because of your genetic information. If your employer finds out some information about your genetic history that may make them have a negative idea on what you're going to be able to do within the workplace. But it's not just you, it's also your spouse, your children, and your immediate relatives around there. So that is what we
Wow.
do. So we investigate. People come to us. It was a lot of law talk right there. So ultimately, what it says is that employers can't discriminate against you because of these things about yourself you really can't change: your age, your sex, if you have a disability, what your race is. They can't treat you differently than other people because of that. That's a great thing about the Title VII. It's you cannot be treated differently because of race, because of sex, because of national origin. It really spells it out that we want people to be treated equitable in the workplace based upon how the laws are written. So we investigate, we look to resolve complaints as they come in. We have mediation departments, we've got investigators. If we can't resolve it and we've reached the point of we found a violation, we may look at litigating the case if we can't resolve it. We also have judges that look in the federal government side. So we have administrative judges. So we have a lot of different departments. We're basically just a small but mighty agency that is here to try and make sure that people have an equitable work environment.
Brilliant. I love that. And so it's reminding the circus industry that there are laws that protect you as an employee, and there are laws that protect your employees as an employer. That's not a context. That's not a narrative that we discuss a lot within the circus arts industry. It's not something that is known a lot within the circus arts industry, and it's just not really a conversation that those laws are applicable to the circus arts industry, which we are constantly trying to again educate and inform that these are your actual legal rights, no matter what type of circus industry job you may have, even though we understand that there are nuances to how you can file a claim and such, which we will get into, Nikki. Can you give an example? I know that I just gave an example of a big claim, and I actually think that the claimant's name was Matthew and not Michael, so I really apologize for those for the person that won the very historic judgment against Cirque du Soleil. I'm very, very sorry. I have a lot of names swirling around sometimes, but Nikki, would you be able to give a different example of a claim within the entertainment industry for those listening in of the EEOC?
Sure. And so, even I did some digging, because the thing about the EEOC, and I'm going to give you a little bit of caveat here, up until a case goes to litigation, we can never talk about anything. So anybody coming to us and filing a claim, it is confidential. The entire investigative process is confidential. The conciliation, that resolution process is confidential. So the majority of our cases that come to us, if we're finding a violation, they're going to be resolved through that conciliation process. So if you think about, we're between 90 and 100,000 cases filed nationally a year with us. And if you look at how
Wow.
many cases that we're taking to court, you're really only seeing 120 or so cases filed a year. So think about that large scale. We're really thoughtful about cases that we litigate because we want to be mindful that we want to make an impact in the industry. We don't want bad case law. We want to know that we are going to be able to really make a difference, get attention on something, really make that positive change for everybody that's involved. And even for those that may not think they're being affected by it, we want to create an environment within the workplace that what brought this to our attention isn't going to happen again. So I'm going to give you that caveat first, because sometimes there's not a lot of stuff I can talk about. Am I aware of cases that have been investigated in the entertainment industry? 100%. But can I talk about them? No. What I can talk is that within the entertainment industry, it's very broad. And so even when I was doing some digging to say, okay, maybe it didn't happen in LA, but could I find it in Miami or could I find it in Vegas? What I find is that cases that are being brought forth from the entertainment industry are a lot of disability cases, a lot of retaliation
Mm.
cases, and a lot of sexual harassment cases. So when I was doing digging, so whether or not we're talking, on the Vegas Strip and you're working in the entertainment industry, whether it's the circus industry or not, we were seeing a lot of those allegations. In adult entertainment, we are seeing disability, race, even some age discrimination, but we're seeing those in the adult entertainment industry that we're seeing not just here, but over in Florida and places like that. So I think that even though there's some things that I cannot talk about because I'm statutorily bound not to talk about it, but I do want to talk about what we're seeing and where
Mm.
we see the problem areas. I will say that very much matches, as crazy as it sounds, because we know the circus industry and the entertainment industry is very nuanced, but it also matches what's happening nationally. Retaliation is the number one thing filed within our agency, and disability is second. That's what I'm seeing as I was looking through all of our cases that we have that are public, and even cases that I know that are not public. We are seeing that type of issue go on, which is exactly what you saw in this case from Cirque du Soleil from 19 years ago. I'm surprised he's still talking to everybody. It's
I know.
wonderful. Um, but yeah,
Very low key.
that came out of the LA office 19 years ago. Um, but it's a
Wow.
discrimination case.
Hmm.
So, or a disability case. And that's still what we're seeing within the entertainment industry. There's a lot of preconceived notions and stereotypes about, in the entertainment industry, they're like, what's going to make us money and what's going to be, an issue for us possibly down the line. And so sometimes those decisions are brought in to the hiring process, to the retention process. And that is not what is allowed, right? It's who can do the best work, not what do they look like or if they have any type of disability.
Mm. How does the EEOC relate to the arts and entertainment industry? I love everything that you said, but I just want to take a deeper dive because, again, this comes back to circus arts industry workers thinking these agencies do not apply to the arts and we cannot really use them. And we are such a different environment. We're so unique. We have such different lifestyles. We travel a lot. We move around. We work for a lot of different companies. We don't stay with the same companies. Maybe we are not even a US citizen. Maybe we are not, we're not fully fluent in English, for example. How can we possibly file a claim with such a staunch government entity or agency when we come from such a novel niche environment that we don't feel has a lot of representation, especially within government?
This is such a great question. And there's a lot there. So let me try to unpack a little piece at a time and bring me back if I didn't answer one of those sections.
Thank you, Nikki.
Okay, first I'm going to say that we very much understand that a lot of people come in and out of the country and work here. They may not speak fluent English. They may not be here legally. They may have an expired visa. Maybe they were here for a while legally and then not. It does not matter to the EEOC. We do not care about your ability to speak English. We have numerous individuals within our agency as a whole that are bilingual. We use a language access teleinterpreter. We do whatever we can to be able to connect with individuals who may not speak English or may not speak English well in the language that they are comfortable with. We don't want that to be an impediment to stop people from coming forward. We don't want someone's immigration status to stop them from coming forward. We are not here and do not care about a person's immigration status. What we care about is whether the employer is violating the law. And what we find is that individuals who may not speak the language well, who are immigrants or new to the country, who may have a fear of government, can be more likely exploited by an employer because they know they're fearful. They know they don't know. And they're like, well, now they're more of a vulnerable employee. We don't want that to happen. And the employer has the obligation to create and maintain a discrimination-free and harassment-free work environment. So we want people to still come forward to us. And, if for some reason they're fearful of that, they can talk to us without even just providing their name initially. Once again, a lot of our process is confidential. So talking to us, trying to get more information, trying to find out if what they have does rise to the level of a discrimination or harassment charge, that can all be done on a confidential basis. Come and talk to us. We don't have to tell your employer that you're here or anything like that. Get the information. That knowledge is powerful, and then make your decision down the line. The fact that people move around, on a good note, we're a national agency. So we get that, right? And if the employer is based someplace else, we'll go back to like your Cirque du Soleil, where the actual main company was based in Montreal, but they
Mhm.
operated here in the United States. And if the employer is operating in the United States, they're required to follow US law, whether it's EEOC law or Department of Labor or OSHA, they're required to still follow the law here. So even if they're based externally, it doesn't mean that the individuals that are working here cannot be protected by these laws. If you are working outside of the United States, it's a little bit more difficult. It depends on
Mhm.
where you're working and things like that, because our laws may not apply. It's interesting, like cruise ships specifically have like their flags out of different countries so that they say they don't have to follow US law, but there are times where they're in US waters. And at that point in
Mhm.
time, do they have to follow US laws? So that's where it gets into some interesting legal kind of digging into the weeds to see what we can do. Um, what else did I get? See, I feel like I hit some of it.
I feel like you hit pretty. I think you hit everything within that. I think, yeah, you are brilliant, Nikki. You hit like every single thing, and I won't get tied up in trying to if we maybe miss one thing, because I think that if we didn't hit it, we'll hit it with the other questions.
Okay.
Yes, and I think the follow up to that, I would just say, is what you're also saying too, is Nikki, is because each case can be so unique. Don't just think, oh, my case probably doesn't have jurisdiction. They don't have jurisdiction over my case because it's different, it's unique, blah, 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 blah. You never know. That's why you have to present the case. That's why you have to come.
Absolutely. Like, don't get hung up at times of like, oh, they're telling me I'm an independent contractor. I know that happens a lot in the entertainment industry. You might
Mm-hmm.
be, you might be misclassified. And so, in those
Mm-hmm.
types of situations, I really want you to feel comfortable coming and talking to the EOC to express what is going on. Yes, you may end up being an independent contractor, but you may not. And I bring that up because we technically do not have jurisdiction over independent contractors. But there might be other agencies that once you give us this information, we can refer you to, who do have jurisdiction over independent contractors. So you can use us almost as like a little fountain library of knowledge that we can then like sparse it out, and say, oh, well, we might not be the right person. Let me take you to the right person. Let me show you where you can go if we aren't it. So I think that's a really great thing to say, is like, I don't want people to say, oh, this isn't about me. Or I heard somebody one time didn't get something. And I don't think that I think my case is kind of similar. You never really know. I'm going to also say, particularly in disability cases, every one of those cases has to be analyzed individually. Even if we have a whole group of like 200 people against the same company alleging disability discrimination, each case, just the way that the law is written and applied, means we have to analyze each individual individually. So you may or may not fall into that. And I just don't want anybody to feel that they can't come and at least just talk to us and say, this is what I have. Let me know if this is something that I can pursue, or just to get additional information about it, the law.
Is there a length of time that you have to be an employee? If you happen to be an employee to be able to file with the EEOC, I also hear this a lot. Oh, I wasn't working with them for that long, or it was just one contract, but I really need help, and I'm so down and out. And is there a time limit of, oh, you didn't work for them for 100 days, so there's no way that you could file a claim against that company, because that's another very specific thing within the industry where you bop around a lot and you're not employed by someone for very long, but a lot can happen within that is very detrimental to yourself and into your career, to your livelihood.
Absolutely. So, excellent question. We cover people who aren't even employees. Maybe you applied for a job and you didn't get
Mm,
it. So you're not
mm,
even an employee at that time. We cover people who are temporary workers, who are migrant workers. It does not matter how long you're working there. So you can be an applicant, so you can be trying to get in, you can be employed for half a day and somebody starts
mhm.
using racial epithets and you're like, I can't handle this. This is not what I signed up for. And you walk out. It doesn't matter. You were employed by the employer. The only time frame we have is we have a jurisdictional time frame of 300 days from the date of violation. This means you have to get to us within 300 days of the date of violation. So if you were fired, you got 300 days forward. If you were not hired, 300 days forward. If you're harassed, it's got to be sometime within that 300 days. Okay. So you have to think about whatever the negative employment action is. You have 300 days to get to the EEOC, unless you are in a state, and this is where it gets confusing, in which there's no federal employment practices agency. There's a handful of them in this country, and then you only have 180 days. So the difference is between 6 months and 10 months. But either way, as soon as something's happening, it's better to start talking to somebody. We also have situations where people say, well, do I have to go and complain internally first? Do I have to go to the
Mhm.
employer and tell them that this is happening? And you do not. You always have the right to go outside, whether it's to a state agency, the federal agency. You can go talk to an attorney if that's what you'd like to do. You don't have to go and report discrimination or harassment inside the company. You can if you want. Maybe they'll be able to address it and resolve it. But maybe the person that is discriminating or harassing is the supervisor or the manager or the president. And then what do? Like, you don't feel comfortable going and talking to him, and nothing's going to change. So, of course, you have to have another avenue to be able to report what's going on. So you don't always have, like, you don't have to go and report internally first. We do have, since I'm on like some little jurisdictional things, there is a number of employees that have to be met. So within a 1 year time frame, and if you're right on the cusp, don't worry, we count them out, because some employers are like, oh, we don't have enough employees, but for 1 month you might have. um, it's 15 or more employees if you're filing under Title VII of the Civil Rights Act. So that's your race, sex, religion, color, and national origin or ethnicity. It's also 15 employees for the Genetic Information Non-Discrimination Act, the Pregnant Workers Fairness Act, and the Americans with Disabilities Act. Under the Age Discrimination and Employment Act, it has to be 20 employees. And if it's under
Mm.
the Equal Pay Act, so being paid similarly based upon sex, it's only one employee. You actually compare yourself to the person that had the job before you. So you only have to have one employee to be able to file. So just getting
Wow.
out all our jurisdictional stuff right away.
Wow, that's amazing. Wow, that is so, so, so good to know. And so how do you, well, I wanted to say this first. Many companies within Circus do not have an HR. And so that's another thing that comes up a lot. They have no reporting system. Many times you're reporting to the person that owns the company. So that can be very intimidating. It can feel very retaliatory. It's a very small industry. Everyone knows everyone. And so the chances of someone finding out that you did file a complaint, or that you were unhappy, or that something came up, for others to find out about that is a very big possibility, unfortunately. And so that anonymity, that confidentiality in not having to go into report to that company can be so, so, so vastly important. And that doesn't just come down, again, I want to remind everyone, not just a circus company, but a circus school, a circus studio, a gymnastics gym that has circus inside of it. There are so many nuances to circus. And I want to remind everyone, you are employed in those spaces. So it's not just about doing circus work in a circus company. It's about working with an entertainment company that's hiring you, an eventing company that doesn't specialize in circus entertainment, but that does hire circus workers. So again, make at a festival where you employed as a circus worker. So it goes hand in hand with all these different spaces, and places. And also to remind you, Nikki, that the EEOC is free to file a complaint. You don't have to pay any money, from what I understand, to file a complaint with the EEOC, to see it through. The very big claimant that won that, he got a lot of support from nonprofits that came to his aid because his case was so popular and so public. And I would very much encourage that, actually, I mean, to a certain extent, but they came out swinging for him. And that's why his case got so much national attention, because there were a lot of organizations that helped him, that did pro bono work for him, that supported him legally. And you can actually get a lawyer and get legal representation within the EEOC. But I did want to ask, how do you file that claim? I know we're kind of coming to the end of our time together, Nikki. And so again, I want to remind everybody, this is like the EEOC in a nutshell. Nikki is providing so much information so quickly for us. And so we, again, hope to have future representation from the EEOC and to be able to answer your questions in real time. But that's the importance of showing up to a future listening session where you might potentially get access to someone like Nikki, or Nikki herself, if we're privileged enough. So thank you for answering that question, Nikki, of is it free and how do you file that claim?
All right. I am going to just jump in one more thing right before I get to that, because I want to say that in the entertainment industry, in the circus industry and everything like that, we deal with a lot of customers too. We deal with people that are in also the gymnastics realm that might not be part of that gymnastics school. And so I just really want to point out that an employer has an obligation to make sure that you are not being discriminated or harassed by other people there as well. So the customers that are attending events, to the other people that are working out within the gym and things like that, the employer has an obligation to make sure that all of that is free from discrimination and harassment. So I want to let you know that if for some reason you're feeling discriminated or harassed, that's something else that you can also bring to us. And it doesn't have to be that the employer is doing it. It could be within the worksite itself. Okay, so let me get that. I'm talking really fast because I want to make sure that we hit our time. We are 100% free. Everything about our agency is free. You can file by going to our external website, www.eeoc.gov. And through there, you're going to go to the client portal and you'll file and begin the process through the portal. Our entire process, from mediation to investigation to resolution, and if we take it to litigation, all of that is free. Whatever money, whatever services, whatever relief that is provided through it, you get 100% of it. We get nothing. We are here to provide that service to other individuals. You have the right throughout our process to be represented by your own attorney. As you mentioned, within the Cirque du Soleil case, Lambda Legal stepped up and represented this individual, but you don't have to do that. We are a neutral fact-finding agency, so we're not siding with one side or the other up until the point of finding a violation. And if we do, then obviously we're here to rectify the situation for the person that came forward and anybody else within that workplace. Whew, I did that fast to try and make the time.
You are amazing. Oh my God, that was so fast. Okay, just a couple of more minutes. And, I would say, because we've spoken so much about the employee, a little bit about how should an entertainment company or circus company conduct themselves based upon EEOC guidelines, and how do they respond as an employer to a complaint. I hear this a lot. They are so afraid that people will just come out and file all these complaints against them, and that the complaints aren't going to be real, and that it's going to do so much harm to their company, and that it's going to just be disgruntled people that are going to come and just take over the industry and file all these complaints, and it's going to sink businesses, which we know is not true. We know that people report mostly accurately and truthfully in all these other spaces that I work in and that I advocate in. There are so many cases that are brought, and 9 times out of 10, probably even 10 times out of 10, no claimant is lying or making up or exaggerating their claims against a company or against an employer. And again, there are great employers out there. There are many great employers out there. It doesn't mean that you're doing everything perfect, though. And it also doesn't mean that someone still can't have a complaint against you, even if you're great, even if you're perfect. Again, no one is perfect. So how do they handle that on the employer side? Because they do not want them to feel, again, like this is an attack on Circus employers, because it is not at all. It's just to make this environment more equitable on both sides so that everyone feels encouraged to abide by the law and to create a better environment that is not as toxic and is more equitable.
It's such a great point. I want to say, first of all, that when we educate employers, we really want to like dispel the stereotype of everybody's going to come forward and complain, and the complaints aren't valid. So, we can talk about what came out after the Me Too movement. A lot of people came forward because they finally felt seen, heard, and brave enough to be able to bring some of this stuff forward that they'd been sitting on for years and years. I encourage employers to have in place a process that people can comfortably come forward and bring information, and to encourage it. Let's take away the word complaint because it says so negative, and let's use the word report. I want people to come in and report things in the workplace that I can then address. And when you create an environment where you hold up and you say, this is the expectation of how we're going to comport ourselves at work. And then you reinforce that so that when somebody comes in and reports that something is not going on, and then you hold people accountable. Companies, we're all the people business, and we as an employer can have the best ideas of what we're going to do, and then we may hire somebody and somebody may not just follow what you want. The idea is that you're going to be vested in creating an equitable a workplace where people can really thrive, which means sometimes we got to come in and do the hard work and say, hey, this person may not be doing what I am telling them to do as part of the supervisory role or a managerial role, or even your coworkers. Your coworkers may be treating people, unethically, discriminatory, and things like that. We as an employer we encourage people to set up guidelines. We have policies. I know you say there's not a lot of HR or things like that, but we want to have policies. We want to put them in place. We want to hold people accountable, because when we don't as employers, it sends a signal to the rest of the workforce that either A, I can do whatever I want and get away with it, or B, what's the point of coming forward and reporting, because obviously they're not going to do anything about it. So I'm just going to sit here and put up with it until it gets to the point where I can no longer, and I'm going to leave and find something else. And so now you as an employer are losing really good employees because you're not taking the time to invest into the company culture and creating an equitable, harassment-free, discriminant-free workplace.
So. Thank you so much, Nikki. That was amazing. That was wonderful. And I want to reiterate to everyone, at some point in time, you will be either an employee or an employer. So look at this as a very well-rounded approach of you never know what hat you're going to wear in this industry. And so it is best to be prepared and thinking about not just for yourself, but for others around you. Maybe this information can help someone who's in a tough spot right now. And maybe you're not going through a difficult time. You never know, but it's good to have the information. It's good to also help others. Spread this information of the EEOC, please, everyone that's tuning into this podcast. I appreciate you all. You're such great advocates for the industry. We are trying to change the narrative around this industry and do things that are very, very historic. And thanks to coordinators and outreach, brilliant outreach coordinators like Nikki. We are having more eyes on the industry. And so it's important. If they don't hear from us, they don't know how to help us. And so I want to encourage everyone to file those reports, to get in touch with the EEOC, to tell them your stories, to send them emails about your experiences and what's going on with you, to try to get a meeting with them, and to really educate them so that they can help us in the best way, because that's where we see as well there's sometimes a lack of nuance and information on what our industry is like. And if we don't give up that information, they won't understand, they won't know. These are things that are confidential, like Nikki said. Don't feel like they're going to exploit or that they're going to release your information to someone or that it's going to come back to haunt you in some way. You can be anonymous, as Nikki said as well, and stay protected in that way. Again, these are not the be all end all. No agency or anything is perfect. I won't say that if that happens or if you report, it's going to like change your entire life or protect your job or anything of that nature, but it is a step in that direction, and it is advocating on behalf of yourself, and it is a portal where you are supposed to get assistance. And I hope that it does come for you if you're struggling out there right now. If you're going through a difficult time, you get some type of feedback or assistance that can help you go in the right direction, or even just help you to get to a different space that's better for you. I will end with the Live Like an Acrobat podcast is also available on Circus Talk, the inclusive, independent, and international online network for the circus industry. Circus Talk's mission is to create a level playing field for this industry and democratize access to information. Until next time, everyone, please stay safe and stay healthy. And thank you again, Nikki, so much for your time and for your efforts on behalf of the circus arts industry. We are very, very grateful.
Thank you.